Good afternoon. My name is Alena Shautsova. I am an immigration attorney from Brooklyn, New York. In today's Legally Speaking seminar, I would like to tell you about how you can come back to the United States after deportation. This video is about and for those who were physically deported out of the United States. I received many inquiries from people who were physically deported out of the United States or removed, and they're willing to come back and they do not know what to do. Well, first of all, the first thing that you need to do is you need to get your copy of your immigration file and show it to an immigration attorney who will tell you if, even after you served 10 years that apply to everyone who's been removed outside of the United States, 10 years of being inadmissible, if those years passed, if you still can come back. What would be the situations when you cannot come back, even though you served the time after the deportation in your home country? Well, one of such situations would be if you were removed because of the aggravated felony. Aggravated felony or conviction of an aggravated felony makes a person inadmissible forever into the United States. And if you're willing to apply, and if you would like to apply for an immigrant visa or being sponsored by your relatives like a spouse or a child back into the United States, and if you have an aggravated felony conviction and you were deported because of that, this will not work. As a rule, unless something is done with an underlying conviction, you will not be able to get an immigrant visa. There is a narrow exception to that. The law does state that the Attorney General may grant permission for a person to get a visa, but those are very, very rare cases. So if you have an aggravated felony conviction and now you're thinking about coming back to the United States, I think the better option for you would be to try instead a non-immigrant visa, for which actually there is a special waiver. That waiver waives almost all grounds for inadmissibility, including a conviction of an aggravated felony. But that visa works only if you would like to come to the United States for a short period of time. It's a non-immigrant waiver, not a waiver for an immigrant visa. Do not think that you can get that waiver, come into the United States, and later apply for adjustment of status for an immigrant visa, green card. It will not work. But this is an option. As a rule, the next step for you would be to, after you determine if you're admissible and inadmissible, to deal with the issues of inadmissibility if you are inadmissible. Let's say you were convicted of a crime of moral turpitude. You might still need a waiver. If you're trying to get into the United States prior to serving the time of 10 years, then you might want to consider application for permission to apply for admission. That's a separate application that needs to be filed if you have not served those 10 years for which you're inadmissible after deportation and would like to come back. There are some other situations, maybe many different other situations. For example, if you ever were charged with claiming a U.S. citizenship, unfortunately, there is nothing can be done. Not even a special permission like for an aggravated felony, it's not available. If you were charged with immigration fraud connected to marriage, it's also something that nobody will be able to help you with. Same situation goes for false asylum claims. So there are a couple of narrow situations when if you were removed because of that, unfortunately you will not be able to come back. But there are many, many other situations that will allow you to come back. Let's talk a little bit now about criminal conviction. What if you were removed because of the criminal conviction? You know, the law has been changing a lot, and sometimes it's possible if you pled guilty to a conviction that became basis for your deportation, sometimes it's possible to reopen that guilty plea and work out a better deal with the prosecutor if, for example, when you were pleading guilty, you were not advised of how that guilty plea will affect your immigration situation. So sometimes it's possible to attack that situation that you have with inability to come back by looking at the grounds and reasons of why you were removed and why you got into trouble in the first place. So usually it's a complicated analysis. A complicated analysis is required to understand how one may find a legal way to come back to the United States after removal or deportation. And of course, if it happened recently that you were removed, don't forget, you might be able to file a motion to reopen. It's very important to remember that. But usually it works only if the removal was very recent, less than 30 days, I would say. Then a new lawyer may get involved and do something about it. Or if there were some real factors, really some kind of injustice that was done to you, let's say ineffective assistance of counsel, or the court did not want to listen to your arguments. Let's say you were removed because you couldn't do something on time, you got sick, or there were some other circumstances, and in this situation you also may be able to remove your case. There are some other grounds for removal that you may read about on our website. There's some other grounds for reopening your case that you may read about on our website, www.shautsova.com. And of course, there are many grounds for removal, and each situation has to be analyzed specifically to figure out whether or not those grounds still should be still applied to you, or they don't matter and you actually qualify for a waiver. The website www.shautsova.com, and we welcome questions at 917-885-2261. Thank you.